Let's see.
Right. Great. Good afternoon, everyone. Thank you so much for joining us for our last family law workshop of the year. With us, we have Nancy Harrison, who's our fabulous attorney partner. Just so everyone is aware, this is recorded and it will be available online by tomorrow. So please make sure if you have any questions that you raise your hand and save them till the end. There's a raise your hand icon up at the top if you're tuning in virtually. Otherwise, you can type anything in the chat at the end of the workshop. So Nancy,
All right,
go for it.
thank you. My name's Nancy Harrison. I'm an attorney in Atlantic Beach, Florida, and practice down here in St. Johns County. I'm here on behalf of myself and St. Johns County Legal Aid, who I work with quite often in the St. Johns County Clerk's Office. So today we are going to kind of focus on equitable distribution in a dissolution of marriage case. So we'll go through that, and then at the end I'll take questions, and those questions can really be about anything in the family law realm, and address what we can in the short amount of time we will have. So as I have told everyone before, I always recommend that you at least talk to a lawyer, even if you're going to represent yourself. It's smart just to get some information, see how you navigate the legal system by yourself. The St. Johns County Legal Aid has a flyer that's here, and you can get it in the clerk's office here, that provides the names of some attorneys who will do an hour of time with you at a very discounted rate. In addition, you can contact the St. Johns County Legal Aid Office, and we have clinics there so that you can get some assistance through that office as well at no charge. Okay, so I've always told you that if you're going to represent yourself, please educate yourself. So today in equitable distribution, I'm going to give you some statute sections. So if this is an issue in your case, then you should go get those statutes. They're all online. You don't have to have a special, legal research program to get them, and read them. Some of them are long, some of them you may have questions about, but I'm going to give you the Cliff Notes version today and tell you what they are so you can look at them. So let's start with what is equitable distribution. Equitable distribution is the division of marital assets and marital debts. So how do you determine what is marital and what's not? So from the time of your marriage until the date that your petition for dissolution is filed, whether you filed it or your spouse filed it, anything in that realm is marital. So people go, well, my car is in my name. Well, it doesn't really matter. It is a marital asset. Or I have my own credit cards. That doesn't matter either. It's a marital debt. So anything that happened before you got married would be non-marital. And anything after the date of filing that you earn or incur as a debt, that is also non-marital. So that will become yours permanently and forever. All right, so the first statute I'm going to tell you about is section 61.075. This is the statute about equitable distribution of marital assets and liabilities. It's very thorough. It tells you exactly what is marital, what isn't marital, what you do with the non-marital assets, what you do with the marital assets and the marital debts. And there are some intricate parts of this statute that deal with passive appreciation. So if one party owns a home, even prior to the marriage, and during the marriage, there's money put into that home, whether it's to pay a mortgage or to do, updating on the home, then potentially you have some interest in the passive appreciation of that. Passive appreciation means that just because of the market and what was put into the house, the value has gone up. And sometimes, depending on the market and real estate, during your marriage, it's possible that the value could go down. And of course, at that point, you don't want the passive appreciation because then it becomes a negative number. So please read through that carefully. So we're going to talk about a few things that in particular deal with equitable distribution. So the court is going to classify everything that's marital, everything that's non-marital. The best way to do that is through your financial affidavit. So I brought some here today, but they are all online at flcourts.org. And you can get them here at the clerk's office. This document is so important. It lays out first your income, then all your expenses. And then the last sections are about assets and liabilities. So your assets, people ask, well, do I just list my asset? No. If you know of any marital assets or any non-marital assets, you need to list them. Even if you don't know the value of them, you can put unknown. And the same thing for the debts. So you want to include all that because essentially that document is a snapshot for the judge to see what kind of assets are there and what kind of debts are there. So the more accurate, the better. Even if you own a business and it's not really doing a whole lot, you need to include it, put your value at 0 or unknown. That can be determined later. The financial affidavit is part of what's called mandatory disclosure in family law cases, which includes documents as well as the financial affidavit, which those documents support your financial affidavit. Those things are like pay stubs, tax returns that show your income. And then for your assets and debts, there are certain things you have to provide: bank statements, statements for pensions, retirement accounts, credit card statements. It's all those documents support your financial affidavit. So for the things that you might not know what the value is, eventually you should. And if you don't know it, your spouse should be producing the documents for it. If they don't get produced, you can go to the court and request that they all be produced. Now, there are two financial affidavit forms. One is a short form, one's a long form. If you do not make more than $50,000 a year, you can fill out the short form. I would recommend that you fill out the long form, no matter what. It's a little more detailed. And if you're looking for other relief, like alimony or some kind of support, the long form lists out all your expenses a little more in detail, and the court's going to need that. So I would always suggest the long form. My clients, I make them fill out the long form no matter what they make, even homemakers. I make them fill out the long form. Okay, so read through 61.075 so that you know where you're going with that, and it will outline again what the assets are and what liabilities are. So when you end up in court, if you have a trial, otherwise you can agree with your spouse if you come to an agreement. The court is going to set a date to value each of those assets and liabilities. Typically, it's going to be at the time of filing, but with some assets in particular, like joint accounts where you pay bills, it's a certain value at the time of filing, but it's going to go up and down because you're going to put money in, you're going to pay bills. So the court may value those closer to trial, just because that makes sense. Anyway, so you need to think about that. When you go to the judge, what date do you want to use? Typically, I use the date of filing, except for those accounts where money's coming in and going out. So start there, and then if something needs to be adjusted, you can let the judge know that. Assigning values to the assets and debts. We talked about that. It should be in your financial affidavit. You can amend your financial affidavit at any time. So if something changes, your income changes, the value of your pension changes significantly, your credit card debt changes significantly, then you can amend those things. So what the court is going to do is distribute all those assets. The court starts with the premises that it will be an equal division. So if there's some reason that you think it should not be equal, look at the statute. Are you going to fit in that category? Are you entitled to more than the other side? You know, it happens, but in general, the court is going to go for the equal distribution. What I do, and I believe all the pretrial orders that the courts are going to give you requires you to do one. It's called an equitable distribution worksheet. So I create mine with listing the asset or debt, so naming it. In particular, if it's a bank account, put the last 4 digits. That way it's very clear what that account is. And then you're going to put in a value, which is the full value. So for instance, a house, it is what the value is of the house. Then you're going to put any debt that's owed on it. So like a car is going to have a value. I always get my clients to use Kelley Blue Book value for that. If there's any debt on it, then that would go in the next column. And then the third column is the net value. So now you've taken the full value, subtracted any debt, you have a value that the court can distribute. And then the next 2 columns for me are husband and wife. And I assign those to either the husband or the wife. And when you get to the bottom, you add all that up. It should be equal or close to it. If there's a big disparity, then there's the term an equalizer, which means that someone may have to pay the other person to make it equal. And sometimes you can shift things around a little bit. So if somebody has a retirement account, you can take that equalizer, if you will, and fix it at the top of the spreadsheet so that it comes out to an equal amount. So what I mean is, let's say the equalizer, if it's unequal, is $10,000. But there's a way to take $10,000 from one party's retirement account and put it in the column that needs the equalizer. And then you end up with the 0, you know, you have an equal at the bottom. So that can be done as well. But the court is going to want you to present something to them as to how you want that distribution done. So it is a lot of work, but again, when you get to trial, you need to be educated. And how do you prove those values? Most of the time, you can use your own statements, but sometimes you may have to subpoena those documents, get a record custodian wherever they're at to sign an affidavit, and then you can get them in like that, which is a whole other issue as to discovery and how to do those things. And we've talked about that a little bit. So once you get to court, you've given the court what you want to do. That's essentially, you know, what the court is going to use. It doesn't mean they'll always agree with you, but it gives them a start and make your argument as to why you think that's the best way to do it. If you have non-marital property, assets or debts, I always list those at the very bottom of my spreadsheets because the court also has to identify those. So, you know, put in whose it is, wife's separate pension or whatever it may be, and or even inheritance. Some people inherit money. As long as you keep it in a separate account, never commingle that money with joint money, then it's non-marital, and you need to list it because the court has to identify that and put it in its judgment that it belongs to one person. The other person's not entitled to a piece of that. So the next statute I want to discuss is section 61.075. We now have a separate statute that deals with retirement plans. So you don't necessarily have to cite these statutes when you're filing your petition or filing a counter petition, but it's good to read it. This talks about how the court deals with, in particular, military pensions and retirement, but it does address all. So again, it's a short one, so that one's pretty easy to understand. The next one that deals with equitable distribution is 61.077. This could be an important one, in particular if one person is staying in the marital home, which is a property you both own, and the other person's moved out, and ultimately the home gets sold. So it's possible that the person who is paying that mortgage, the homeowner's insurance, property taxes, even homeowners association fees, you can get a credit for that, for half of it, because, you know, your spouse, technically, if you're still married, should have been contributing to that. So read that as well. You can make an argument to the court if you're entitled to those kind of things upon the sale of the house. So it kind of puts a little credit in your column and you'll get more than half of the net proceeds from that, or request it anyway. So I talked a little bit about filing your petition. You need to be very clear in your petition whether you want an equal distribution, whether you're looking for an unequal distribution. You need to put that in your petition or a counter petition. If you do not ask the court for something in your petitions, your counter petitions, even motions, you cannot get the relief. So it's better to throw it all in and then let the judge figure it out later, what you can and you can't get, but at least you've requested it. Because if you don't, again, you don't get it. There are a lot of factors in these statutes, so read through those factors. Those are where you get to make your arguments about, in particular, like an unequal distribution. The court is going to look at if you have a homemaker maybe at home, you know, what did that person contribute to the marriage, to the spouse, caring for the children, getting their education done, economic circumstances. So maybe there's one party who's the breadwinner, the other party works part-time or has a lesser paying job. You know, that's important for the court to know. The duration of your marriage. So if you've been married a year and somebody's a billionaire and making $1 million a year, you know, alimony is going to be difficult for you to get, but maybe you might get to make an argument for an unequal distribution just to have a little extra money to take care of yourself till you can get a full-time job, making the money you need to. As somebody interrupted their career to stay home as a stay-at-home mother or father. That's important for the court to know. You can also make the argument that you have assisted your spouse by staying home and taking care of the children and being a homemaker to help him further his career or her further her career. So that's a factor as well. Whether an asset should stay as is with one spouse. So for instance, if one of the spouses has a business, the other spouse has never been involved, you know, clearly the court is rarely going to make the couple work together. If they work in that business together, that's probably not going to work after a divorce. So the court is going to look at it if somebody's arguing, you know, this is my business, I started it, you know, am the one who contributed the most. The court is going to try and keep that intact to one person. Let's see. Even the marital home. If you have minor children, if you request it, more likely than not, if you can afford the mortgage going forward, you know, one parent is probably going to stay in that house until the youngest child reaches 18. And then the house can be sold and the asset divided at that time. Did somebody intentionally waste money during your marriage? So people go, what does that mean? So it's called dissipation. So sometimes you have gamblers in a household. Sometimes people have affairs and they spend money on that. And if that money is not benefiting both of the parties, that is considered a dissipation. Now, when I have a case like that, I will probably not make a big deal of it if it's $1,000, because you just spent more on me to figure it out than what you're going to get back from the court. So it would have to probably be $10,000 before I go to the court and go, okay, my client needs $5,000 of that money back, because that's not fair. Essentially, is where it comes from. And that could be a lot of things: gambling, affairs you spend money on, drug use sometimes. You know, there could be a lot of things, and it comes down to, did you deplete marital assets to further your own benefit? Now, the statute says within the past 2 years prior to filing. But the case law says, depending on what it is, you can go back further than that. I, in particular, have had a case where someone hid money and It was hidden long before the 2 years. And we ultimately got the money back into the distribution, and the other party had to pay my client half that money, which was substantial. And then in almost all of our statutes in Florida, there's always the catch-all, which is anything else, that would serve equity and justice between the parties. So think about that. There may be something that's not specifically listed. You can always make an argument to the court. Doesn't mean you're going to win, but make the argument. If you don't make it, the court will never hear it. Let's see. Now, have people ask me this all the time. So what if I get, A, B, and C as an asset? Some of it may be a payment of an equalizer. It could be a cash asset. What happens if they don't do it? So you can file a motion for enforcement. A court cannot hold someone in contempt for not paying equitable distribution or giving you stuff. I mean, personal property, things you're supposed to get out of the house. If your spouse doesn't give it to you, you can file to enforce it, but you cannot have someone held in contempt for that. And potentially you can get attorney's fees. That's always based on one party's need for it, the other party's ability to pay it. Whether in a contempt case, if the court were to find someone in contempt, they can award fees a little more loosely than just looking at the need and ability to pay. So remember that if somebody's not giving you something, you can move to enforce it, but you're not going to get the court to hold someone in contempt. So wanted to point this out to you. As part of your marital assets, let's say I give my spouse, I don't know, $10,000, and he puts it in his own account. That is marital money. Any interspousal gifts are marital, probably because you use marital money to give it to him or buy it, whatever it is. There is one thing I have people ask about, and that's an engagement ring. An engagement ring is technically whoever has it, the female, the male, that belongs to them. And the reason why is because that is in contemplation of your marriage, and technically a marriage is a contract. So you have to have an offer, an acceptance, and the actual agreement solidified. So in this case, it's the marriage, it's an engagement ring. The other person accepts it, says yes, and then you get married. So it is now yours. That was outside of your marriage. It's non-marital property. There are some case law, and I have seen where it was an heirloom to the husband's family, and the court would award it back to the family. In particular, if the marriage was rather short, because it does divest that family of that piece of jewelry forever. And it could have been in the family for hundreds of years. Who knows? Now, on pensions and retirement accounts and things like that, we talked about what was non-marital before and after the filing. So what happens with that? So there's formulas out there, and the court can help you with that. They are in the statute, but they can be a little complicated. So what happens is, if you have a 401k, anything that was in that 401k prior to your marriage is non-marital. So I always have my clients, sometimes it's difficult, you have to go way back, but get a statement from that point at the time you got married. And then you're going to have a statement at the time of filing. So then we can take this piece in the middle, and the court can put in a calculation that will award you half of what is in that block of time. There is such a thing as a qualified domestic relations order. A lot of these companies that hold 401ks and retirement accounts are going to require that separate order. Unfortunately, the people who draft those orders, they cost money. So when you go to the court, and if you're looking to get, your spouses, and you don't have the money to pay for that qualified domestic relations order, ask the court to have the other side pay for it. So you can get that in place. What the court does is enters that order and then it goes to the administrator of the plan, the retirement plan, and they divide the money. I also caution you with, if you are not of retirement age, you need to make sure those funds go into some kind of similar account. Don't take them out unless you absolutely have to, because there will be tax penalties if you're not of retirement age. And you don't want to do that. We already give the government enough money of ours that we earn. So be careful with that. If you have to have it, you have to have it, but you're going to end up paying the taxes on it once it's transferred to you. I think that is really, I mean, in a simple way, what equitable distribution is. So I have talked before about the order that a court will look at something. So I've always found it ironic that the acronym is PEACE, PEACE. And the court does this in this order in particular, so I'm going to explain what each of them are and why the court does this. So P is parenting issues. So parental responsibility, time sharing, how much time you get to spend with your children. The court needs to know that before it moves forward. Equitable distribution is the E. The court needs to know what kind of assets and debts each party is getting. Because in some cases, people are going to get an asset that can earn income, which brings us to the A, which is alimony. So in determining alimony, a court needs to know what both parties' income is. If there's something from the equitable distribution that's going to create an income, the court's going to include that and put that in that party's column to determine if alimony is going to be awarded. And then you have C, which is child support. So we walk down that. The court needs to know under the parenting issues how many overnights you're going to have. The equitable distribution brings you to income under alimony. If you're going to get alimony, that is also income. So to determine the child support, the court needs to know all those things to calculate child support. And E is everything else. Typically, that's attorney's fees. So maybe it should be Peace Cup, but it's the E because it could be a lot of things, the everything else. So that's the reason the court goes in that order, because we have to build on what the court can do and the information it needs to get to the end of the case. Now, if you have an equitable distribution issue, and that's really your main issue, there's not an issue of alimony, maybe you don't have any children, the court is going to order you at some point to go to mediation. 99% of those cases should settle. I mean, that's pretty simple. The statute says equal. People look for unequal, but you can come to an agreement. So typically 90 to 95% of all family law cases settle unless alimony is a big issue people want to go to trial about, and big children's issues. So other than that, everything else is statutory, so they should be pretty easy to resolve. Just remember, when you go to mediation, even if it's an attorney who's the mediator, they're not supposed to give you legal advice. So again, educate yourself. When you get there, know what you want, be ready to negotiate. The reality is you should ask for more than what you're willing to settle for, and know you can come down to that. So when you go to mediation, typically the mediator is going to draft the agreement and you should sign it that day. That's the best way to do it, because people go home and change their mind. So get it in writing, get it signed, and then your case is resolved. And then you just let the court know that you've resolved your case. Here in St. Johns County, there's case management pretty often in a case. So at that point, the court would probably enter your consent final judgment and you would be divorced and your assets divided and all other issues addressed to be finalized so you can move on with your life. And that's pretty much it. Listen, that was kind of short today, but I'm open for questions of any kind.
Works. Anyone that is tuning in virtually, please, like I said earlier, raise your hand. I do not have the ability to unmute anyone, so you will have to unmute yourself. Just keep that in mind. So if anyone has any questions, by all means.
You have a question?
Yeah, are sessions online somewhere?
Yes.
They are.
You can check out our YouTube, and all of the stuff is available on our Facebook as well.
Okay. Is VA disability included in gross income?
It is.
Both my wife and I are both 100% disabled. I have retirement income
Mhm.
from the military. She does not. I know there's overlapping months with the total months of service formula.
Right.
Now, is that the only way to go for, or will they choose a different number?
Yeah, so DFAS is good. They actually have a change in that, and it was made in 18 or 19, the way DFAS deals with that. But they will, if there's and it's not called a qualified domestic relations order, it's called a military division order, I think. And once they get that order, they will look at it and they will either approve it based on what they use as a formula. And if you're having someone who's supposed to prepare those things, they typically know, so it'll get approved like that. But if there is a problem with it, it'll kick back, but the court will divide that appropriately, just the marital portion.
Okay, and we have more than income, the two disabilities and the retirement.
Right, right. So she would be entitled to whatever happened to marital.
I did the formula, she's like $800, because it's only
Right.
$1,000.
Were you married 10 years during the service time?
Yes,
Okay, so DFAS will also be able to pay her directly.
Okay.
If you're married less than 10 years, then typically the military service member is gonna have to get the money and give it to the spouse, right? Which can be an issue because it's all, you're paying all the taxes. And then she's
And
gonna get
no
this
taxes.
bonus, so. Well, it depends on the amount of taxes for some people.
Right.
To get their pensions, yeah.
only 3,000 a month, so it's not really.
Yeah, well, I mean, I get it, but it's still taxable.
How do we validate a house? We just use a Zillow or
If neither one of you have an attorney, it's possible that the court will accept that. Otherwise, spend $300 and get an appraisal. That's the best way to do it. Sometimes you can also get a realtor to just do comparables.
We did that already.
Okay, so that's a pretty good judge
And
of the
then
number.
we make approximately $300,000 off the house after we pay off the debt.
Mhm.
Now, that's like guessing the, not including the 6% realtor fees and all that stuff.
Right, closing costs.
That's how they do that.
Mhm, yes, so it'll have language that you divide the net proceeds, so the net, you take the gross, you pay the mortgage, any other notes on it. And then the closing costs, which would include the realtor's commissions and whatever the closing attorney or closing person is charging, they're not all attorneys in Florida. So, and then you have a number, and that will be divided equally.
Is there, what ways are there, if I want to keep the house? Do I have to refinance the house to get her name off the mortgage?
If you come to an agreement, it may not be necessary. Typically, in case of if someone's gonna keep the house in an agreement, they will give them a certain period of time to refinance it, and if you can't refinance it, then it has to be sold.
So, so,
Yeah, because one person's not gonna be able to get another mortgage, probably, if
Yeah.
they're on one already.
we're going to 2%.
Yeah,
now.
and if you don't pay it, then they're gonna come after both of you.
So cheap on this house,
Yeah, you got a great rate.
that we bought right during COVID, so it's.
It doubled in value as soon as you bought
And
it. Right, which is nice.
you can't afford, neither one of us can really afford a place anymore.
Yeah, rent is
So I don't know what
crazy.
to do. Yeah.
Yeah, it is.
Can the court change an agreement that we have, like, between my wife and I?
If it's about equitable distribution, no, they're gonna typically approve it.
Okay,
If it was about a child issue, yeah, the court has to look at the children's best interest and what it is.
we have like the children's issues, we have one over 18 that's still in high school.
Okay,
Now, does child support go to that one as well, or?
it would go until the child is 19, as long as the child seems to be progressing so that there's graduations imminent.
Okay. And then we don't know where they're gonna live, but they're probably gonna stay with probably me,
Okay,
100% of the time, so they can go to the schools they want to.
okay,
Now, they're old enough, one's 18, one's 16. We don't really need to like, hey, I spend 50% of the time at this place, 50% of the time at that place. And they're on their own. They're gonna do whatever they want to do.
right,
It's just like the bedroom's just gonna be my house.
right, where they lay their
How would
heads at.
we stipulate that in the agreement?
So that there wouldn't be any child support, is that what you're talking about? Or are you
no,
gonna
no.
calculate child support? Okay. So a court has to approve anything that deals with children in their best interest. The court probably wouldn't have a problem with the children staying at your house every night. But the court's gonna look at the child support number, because technically you would be supporting the children more than she would be. Because you have to pay for a place where they can sleep, you're paying for food in your house. I don't know if you have girls or boys, but those kids at that age are eating a lot.
And not really against.
Yeah, so, I mean, the court, you can ask that there be zero child support, but typically a court is only gonna approve that if the child support guideline amount is minimal. And I say minimal, it's usually under $100 or something. But you can agree to it and try to get it to the judge that way and explain the situation. I take one's 18 and how old's the other?
16.
So, I mean, they're on their way out.
Yeah.
Yeah. Probably will get approved, but I'm not the judge.
And like I said, neither one of us has the job, so we both 100% stable.
Right, and your income is gonna be pretty much the same once she gets part of your pension
Yeah.
too, so.
If we do have to go to mediation, when is that decided and who pays for that?
The court will send you, these case management conferences you go to, at some point, the court's gonna send you to mediation. They'll send you to a mediator who's non-expensive. So in general, the mediators I use are also attorneys. So my client is paying their hourly rate for the mediation. It's divided between the parties. At the court-ordered ones, they're usually based on your income, so they're pretty minimal.
What do you mean by minimum?
Like $60 or $120 for your entire mediation.
Oh, okay.
So it's a great deal. And they're good mediators. It's not like they're subpar. I use the same people in Duval County. I have clients who don't have one of them.
Anything else you think comes up a lot?
No, I mean, great question. Sounds like you've gone through it.
We haven't filed yet, so.
Okay, we'll take these statutes and copies of financial updates with you.
Yeah, I already got paperwork packet from them. I just had to use the long form now, I guess, because my disability is included, so.
Yeah, it is included. And take one of those forms if you need to go to St. Johns County Legal Aid. You can do that, or, call an attorney. I think they're $150 for an hour.
Okay.
It's a good way to get a lot of information and some legal advice.
Yeah, these forms are confusing. Trying to figure out.
They are, and even the instructions are confusing. But those in particular are what we do at St. Johns County at our clinics. We go over those forms with you to make sure they're right. Okay. And most of that is virtual now, so it's really a phone call. We need to meet with you.
One of the questions that was in this was how much we spend a month on child's medical. So we use TRICARE for military,
Right,
and now that covers the whole family. And
Right.
my wife's 100% disabled, and she uses TRICARE under me.
mhm,
Now, I don't use the TRICARE, I just use the VA. So
okay,
that money that's like $700 a year, $60 a month. Can I just bring that whole $60 for the kids? Because if I didn't have the kids.
Well,
I
if
would
it's
pay that.
covering, I mean, post dissolution, it's gonna cover you and the 2 children. She will have her
And I
own,
never use it because I use the MBA. But it still covers me.
right, but it's still coming out of your money.
Yeah,
So technically it covers 3 people. You're just not, it will post dissolution. You're just not using it.
correct.
Yeah, I would put down $40 for the kids and $20 for you
Okay.
as a cost of the health
Because yeah,
insurance.
that's what $60 a kid is just for that, because I didn't have that.
Right. Well, I mean, you could put it in that. It is a child support calculation number, really. Okay, well, good. They were great questions. You thought about it all.